Okay, first off, just your name.
Neil Pitchinen.
Neil Pitchinen. The floor is yours. Have your say.
Well, I suppose I've been invited here to explain the situation that's gone on in Australia that has been hidden from the public for going on to 50 years now. And that situation had been a worldwide trend to remove the rights of people gradually over time so they would get used to the change. And it was at a time when the European Union was becoming prominent, and the UK entered into that arrangement of a new community where, to do it within law, they had to bring the law system of the United Kingdom under the law system of the European Parliament, which in effect demoted the Queen to being a citizen, and so she was no longer the sovereign in respect of creating law for her own community and all the colonies or places underneath her authority. And so it started a pattern where they removed the Queen of the United Kingdom from all these places which the people had allegiance and deserved her protection under that arrangement of allegiance. So in 1971, when the UK entered the EU, Australia entered into negotiations to remove the Queen of the United Kingdom from our lawmaking. And so started the process under the Whitlam government to make arrangements to create a new title of the Queen, which would be directed by Australian ministers instead of UK. And they entered into negotiations to make those changes, but before they did the change, there was a memo from the Attorney General to the Foreign Affairs, identified as Minute 445 of Lyndall, in which they acknowledged there was no authority to create or alter the title of the Queen. And yet, 6 months later, they go ahead and do just that and make a new title of the Queen under the Royal Styles and Titles Act, without any fanfare to the Australian people that they had just changed the title of the Queen and therefore the entity under which they will make law and provide justice. The fact that the UK Queen is a defender of the faith, at the coronation oath is sworn to the Bible as the standard of law for which all law derives. The Australian title had no coronation, no standard of which the Queen is to be referenced for law. So we had now a sovereign with no standard upon which we can protect our society and secure law as it had been fought and won for freedom through the ages. They changed the reference of law in our Justices Act by changing Section 80 from the Common Law of England to the Common Law of Australia, which means we no longer have the protection of the Magna Carta, the Bill of Rights, the right of petition, and these other standards of constitutional regard. And so now the justices and the parliamentarians, when they make law, have no real guidance about what standards we can apply. We can apply any standard whatsoever. So now, having regard to the standard that we no longer have, we've now lost our protection that is biblically defined and always had been subject to the maxims of law. So we had our heritage, which are thousands of years old, to protect us. Now, in order to do that, the Gough Whitlam government had to remove the authority of the Australian people. And the authority of the Australian people legally is termed the Commonwealth. So Gough Whitlam went to remove the authority of his community, or our community, by removing the word the Commonwealth and leave us with Australia. And a journal came out, published in 1974, which defined that to be now referenced under Australia instead of the Commonwealth of Australia meant we came under the authority of the government. Now that's strange, because the government was created as a servant of the people under the Constitution, and now they switched roles with the people to make the people the servant and the government the authority. And the only way they could do that is by removing both the Commonwealth and the Queen. So the problem they have at the moment is they identified that was a problem constitutionally, and they were looking towards identifying all these problems and now legalising everything that was illegal with regards to these anomalies. So they made recommendations in the Constitutional Report of 1988, making recommendations to pass bills through the Parliament to hold referendum to now legalise this new standard. But none of those got taken up to be put through to referendum, because it would have raised the awareness that in fact the government was now operating illegally. And if they didn't pass it through by referendum, they would have been stuck with this situation where they had been operating illegally for, I suppose, 15 years at the time, and they would have had a big problem of trying to defend litigation on this criminal activity of being in contempt of the Constitution, the Sovereign, and the Commonwealth. And that's defined in the criminal codes of the states and the Crimes Act of the Commonwealth. So after the 2,000-page report of 1988 was published, it was basically hidden, and I only come across it in recent times, and we went through it and identified certain core principles that they had breached, and we published it under a character called Darren Dixon, who has constitutionwatch.com.au and publishes similar sorts of information that's important to our people. So, having put this into the courts and to the government, we've never had any rebuttal as to the position that the government has now made, that in fact they are operating without authority, and they're looking towards getting to a position where they'll run a new referendum to start a republic, to have a brand new start, so they're not caught in this criminality of having removed the people's authority, being the Commonwealth. And it seems that they have a hard time trying to press that promotion, because there are all sorts of problems in trying to set up a new republic, whether it's going to be protective as our constitutional monarchy can provide, or whether they'll set a standard where it'll be even worse than we currently have. So it's a situation where the people need to be aware that the government is promoting values which are against those which is good for our community, and I believe it's all part and parcel of generally and gradually removing our rights, whether it be the amount of taxation that we're subjected to, whether when they took away the rights to bear arms, whether we have the right to decide our medical choices and they take that away, whether we have rights to determine the how we will raise and maintain our children, they're taking that away, So these removal of rights are a gradual erodation of our rights, where we're getting to be made used to this area, and then when the next one comes, it's only another general, gradual step, which is easier to do than doing it all in one hit. And I believe that the Australian people are bewildered how we've got to this position, and they're really not sure what they can do, because they're now making it illegal to even raise an objection. And the whole English law system was built on the Protestant movement, which is inherent in our situation, and protesting is part and parcel of our rights. So until we get a return to our core values that the Queen has sworn to in her coronation, being the values of and customs of our people, and we arrest the progression of the erodation of our rights by parliamentarians, and that the judges take courage about taking up their judicial duties in accord with that which is made by law, not made by the current removal of that law by going to these fake fictional standards that are not supported by law. We're going to ruin our society.